Hello and welcome to Business Law Online. My name is Professor Ertel. I will be your instructor this semester. For those of you interested, I am an attorney. I've been practicing for almost 20 years, mostly in the area of civil transactions and civil lawsuits. Um, just a few housekeeping issues. For those of you who have the book, the Cheeseman book, great. My feeling with respect to older editions is older editions are fine, especially for law. Law doesn't really change that much one year after the other. Just that if you do get an older edition of the textbook, make sure that it has all the chapters that we will be covering. It's important to have that. And I do expect you to have the textbook and to read it, ideally before you listen to my lecture. It helps. Uh, Obviously, I'm doing this by video. This is a decision on my part. I decided to do it by video because I really wasn't satisfied with the preloaded law course that was offered, so I decided to do my lectures online instead. So with that being said, I'm going to run this class as much as I can like a traditional law class. Now, obviously, that begs the question, how are you going to, I can't take your questions as you're watching this video, but please, as you're watching this video or these videos over the course of the semester, take notes. And if you have questions, email me your questions. I will respond to your questions. I'm pretty good about responding to emails, usually the same day. So please email me your questions. Questions are an important part of the learning process. They help me to see if my students are getting the material. Because if you have a question, chances are other students may have that same question. So maybe I would actually even post that up on the discussion board. So it's important, please, for you to take notes and email me your questions when you can. As I said before, I am an attorney. I've been practicing now for almost 20 years. And I love the law. To me, the law is both very philosophical. On the one hand, you have Thomas Jefferson. He was an attorney. He wrote the Declaration of Independence, which is really a legal document as much as a political document. And on the other hand, you have attorneys every day, today, going into court and other venues, protecting their clients' rights. So it's just both very philosophical and also very practical. This is a challenging course. The material is not easy. It's hard. Law can be foreign at times, so it's important for you to really pay attention to these lectures. Take your notes, and again, send me your questions. It's not an easy class. It's not an easy class at all. Now I know, anytime I teach this class, there are different groups of students. One group of students, they're interested in going to law school, and I think that's fantastic. And any questions you may have about the process of going to law school, or what law school is about, or what was like the experience, please don't hesitate to reach out to me. I will always tell you what I think. And then, of course, there's another group of students that say, the only reason I'm taking this class is because I need to graduate. That somehow, I can't graduate on time, or I can't graduate at all unless I take this class. That may be true. You're thinking, oh, I don't want to practice law. I want to go into business. Well, in today's business environment, you need to know the law. It's important. What I teach in this class will apply to your business practices, I guarantee you. The old defense of my attorney didn't tell me so. My attorney didn't tell me it was wrong. My attorney didn't tell me it was illegal is no longer available. This is the post-Enron world. That defense is no longer available. All right, so with those matters out of the way, I think a good place to start is, how would you define a law? Right, we all know what laws are. Right? You have to stop at red lights and stop signs. You have to pay your taxes. You can't attack people. We all know what laws are, but how would you actually define a law? And if you opened up a dictionary, you might find a definition kind of like this. Laws consist of rules that regulate human behavior with the intention of protecting persons, or other legal entities, and we'll talk about that when we talk about corporations. They are legal entities unto themselves, and their property from unwanted interference. Now, often that's accomplished through some kind of punitive edge, right? That if you injure somebody, you're going to be punished somehow. Uh, that sounds a lot like what kind of law? Criminal law, right? But actually, there are two types of law. We have civil law, and we also have criminal law. And I want to talk about the two because I don't want you using terms interchangeably. It drives me crazy when students do that. Civil law and criminal law are very different. Now, they both may have a punitive edge, meaning some kind of punishment, but they're very different. Civil law involves primarily private matters and also primarily private parties. John Smith versus Jane Doe. John Smith, the plaintiff, is suing Jane Doe, the defendant, for money. Why? Because John Smith is alleging that Jane Doe caused some kind of injury, either breach of contract or some kind of personal injury. That's one function of civil law. Another function of civil law is to make sure that transactions are carried out smoothly. And when I mean transactions, I mean contracts. So you, as a business person, should feel confident that when you sign a contract, that contract is enforceable, and as such, it's incentive for the other party to carry through with the terms of that contract. Excuse me, my allergies are acting up. Now, by comparison, criminal law, the purpose of criminal law is to punish the offender, to reform the offender, to deter others from engaging in the same kind of behavior, and yes, to serve justice, right? To serve justice, to make the victim whole, so to speak. So it's a little bit different, and usually this is accomplished by some form of incarceration or probation, maybe even parole afterwards. In other words, a loss of liberty. Right? We're talking about taking away somebody's liberty. Now, I want to compare and contrast civil law to criminal law, and I want you to keep these two concepts, understand the differences between the two types of law. As I mentioned before, with civil law, we're involved with private parties mostly. I mean, the state sometimes is involved with civil law. New York State can sue people, and vice versa. People can sue New York State for money. But primarily, civil law involves private parties in private matters. Okay? By comparison, criminal law involves public offenses. In other words, a violation of the criminal code, the penal code, whatever it is the state that you live in may call its criminal laws. What has happened is society has made a judgment that certain behaviors are so abhorrent, so horrible, that if you engage in those behaviors, you need to be punished. And you need to be punished and branded as a criminal. And that punishment is usually, as I said before, some sort of loss of liberty. Now, with that being said, I want to talk a little bit about the role of the victim in both. Now, the victim in a civil lawsuit is referred to as the plaintiff. The plaintiff sues the defendant. The plaintiff, John Smith, sues Jane Doe because John Smith believes that Jane Doe has caused some kind of injury to him that has caused him to lose money. Now, in a criminal prosecution, it's the state that brings the lawsuit against the defendant. It's not the victim. It's the state's rights. The state is actually vindicating its rights against that defendant. Its right to bring a criminal prosecution, to bring criminal charges against the defendant. Very important distinction there. Why? Again, the role of the victim is very different in both. When a client comes in to see me for the first time, maybe the client wants to sue another party for whatever reason. And I always tell them, here's my card, this is my number. If you move, let me know. If you move and get a new phone number, call me up and give me that new phone number. Why? Because I need to know where you are. Why? Because without you, your lawsuit will be dismissed. Remember, as a plaintiff, you are going into court and you are asking the court, the judge, the jury to give you something. You're asking the court, the jury, to give you money. If you don't have the wherewithal to show up when the court wants you to, the court is going to dismiss your case. The court has got 2,000 cases on its calendar. If it can dismiss a case, it will. You better have the courtesy to show up. So the victim, the plaintiff in a civil lawsuit is essential. In a criminal lawsuit, it's a little bit different. In a criminal lawsuit, the victim is really nothing more than a witness to the crime. Why? Because again, it's the state that has the right to bring the criminal charges, not the victim. There really is no such thing as victim's rights. The victim is just really a witness to the crime. At the end of the day, you don't need a cooperating victim to bring a criminal prosecution. The prosecution may decide that there's enough evidence otherwise to convict the defendant. A case that involved a high-profile case that dealt with that issue was the case of Warren Moon, the NFL quarterback. He had retired, and he was arrested for beating his wife, a variety of assault and domestic abuse charges. Well, his wife, who was originally the complaining victim, recanted her statement. And you would think that maybe the prosecution then would drop the charges, but they didn't. The prosecution believed that there was enough evidence to prosecute, charge, and convict Warren Moon on those criminal charges. And it led to kind of an odd scene in and outside the courtroom. The prosecution went, and the case went to trial, and the prosecution presented its case, all its evidence that it had. And at the end, the jury found Warren Moon, the criminal defendant, not guilty. The victim of the crime, his wife, jumped up and gave him a big hug inside the courtroom. Outside the courthouse, they were holding hands, hugging and kissing. And it was kind of an odd scene. But again, it demonstrates that you do not need to have the criminal victim's testimony in order to prosecute a criminal defendant. Another important distinction between the two is the burden of proof. In other words, how much evidence do you have to be successful? Now, in civil lawsuits, remember, we're talking about A suing B for money. So all we're talking about is money. I know money is important, but the law doesn't consider it as important as other things that we're going to talk about shortly. So the burden of proof in a civil lawsuit is known as preponderance of the evidence. Preponderance of the evidence simply means this. Is it more likely than not that the defendant's actions cause the plaintiff's injuries? If yes, the defendant is liable. More likely than not. If you wanted to put a number on it, what number would that be? What percentage? 51%. That's a pretty low threshold. By comparison, in criminal lawsuits, the burden of proof is not proof beyond all doubt, not 100% certain, but proof beyond a reasonable doubt. That is the highest level of burden of proof we have in our legal system. And that has been defined as follows. It's doubt that would cause you to hesitate in making the most important decision of your life. And it is an important decision. When you are deciding whether or not someone is guilty or not guilty about a crime, what you're talking about, if you find them guilty, is taking away their liberty, taking away their freedom. The law considers this a lot more important than money. So if you had to put a number on it, if you're a juror, proof beyond a reasonable doubt, 90, 95% certain, that's probably proof beyond a reasonable doubt. Much higher than 51%. much, much higher than 51%. But not proof beyond all doubt, not 100% certain, just 90, 95% certain that's enough. Some other important distinctions. In a civil lawsuit, the plaintiff sues the defendant. In a criminal lawsuit, the state prosecutes the defendant. An important distinction between the two. When you sue, you're looking for money. When you prosecute, you're looking to put someone in jail. That's an important distinction as well. All right. So keep that in mind. Civil law versus criminal law, very important. All right, now, what makes a law valid? If I were to tell this class, everyone here must eat their vegetables every night, is that a law? Can I make a law and impose it upon you? Yeah, instinctively, you're all saying no, or you should be saying no. I can't impose a law. Who am I? Well, a law has got to come from a controlling authority. A law has got to come from a controlling authority in order for it to be valid. Now, I want you to dust off your brain cells from high school, in your civics classes, and your social studies classes. Who makes the law in the United States? Right? You should know. Congress makes the law. Legislatures make the law. State legislatures and Congress, they make the law. They are the controlling authority. But we also have a second controlling authority in the United States, the courts themselves. Courts do make law. They make law when they write their opinions. A lot of times there's a conflict between the law. We see this between the controlling authorities, I should say. We see this, for instance, in the same-sex marriage debate. Out in California, the court ruled that California's definition of same-sex marriage, or California's definition of marriage as between one man and one woman, was unconstitutional under the California state constitution and the U.S. Constitution. But what happened subsequently? There was Proposition 8, and that passed. So on one hand, you have the legislature that says, no, that opinion is wrong, and you have the opinion itself. So you have a conflict between the two. But still, for a law to be valid, it's got to come from a controlling authority. In the United States, that's the legislatures. That includes, at the federal level, Congress, which includes what? The House of Representatives and the Senate. And at the state level, includes the state legislatures. In New York State, where I live, and probably most of you live, we have the New York State Assembly and also the New York State Senate. Right, they're the legislatures. But courts also make law, and they're also a very important controlling authority. Now, where does law actually come from? Law is not arbitrary. There is actually a philosophy behind it. And in the United States, the most important philosophy is the natural law philosophy. Natural law argues that the source of all political rights, of most laws, is some kind of divinity. It doesn't make a difference what you call it. It's some kind of divinity. And that's expressed very eloquently by Thomas Jefferson in the Declaration of Independence, when he wrote, "We hold these truths to be self-evident, that all men are created equal and endowed by who? Endowed by their Creator with certain inalienable rights, including the right to life, liberty, and the pursuit of happiness." This, in a nutshell, is natural law. Another natural law document, very important, the Constitution itself. The Constitution is a natural law document. Another form, another philosophy, of law, another philosophy of law is the historical school. Now, the historical school takes a different approach to law. That law comes from culture, it comes from society, it comes from experience. What works, what doesn't work. Perhaps an example of that, I think, dry counties, dry states. Has anyone here ever been to Martha's Vineyard? Obviously, I can't tell, but if you've been to Martha's Vineyard, you know that there are 4 towns on Martha's Vineyard. 3 of them are dry. Why? Because they've always been dry. They've always been dry. Now, there's no, they may say at this point, well, it's part of our personality, it's part of the character of the towns, but it seems to work for them. It seems to work for those towns. Ocean City, New Jersey is also a dry town. If you ever go to Ocean City, New Jersey, the world's largest liquor store is literally located right across the town border into the next town. It's a huge, huge liquor store. But Ocean City, New Jersey is dry. Why? Well, that's just the way they've always been. And they like it like that. A lot of states have various forms of blue laws. You can't buy alcohol on Sunday or only at certain times. That's also another example of the historical school. Again, the historical school is all about what works, what's our culture, what's our experience, what laws have worked for our society. Another school, an important legal philosophy, is the sociological school. Now, the sociological school holds that the law should be the means to achieve social justice. Perhaps the most glaring example of this is the Supreme Court decision Brown versus the Board of Education. Now, you should know there are a few Supreme Court cases that every college graduate should know, and Brown versus the Board of Education is one of them. It was decided in 1954, and what it did was reverse the 1896 decision of Plessy versus Ferguson. Plessy versus Ferguson held that separate but equal public accommodations was constitutional. In Brown versus the Board of Education, the Supreme Court held the opposite. Separate is not equal. Now, who argued for the Browns? Well, this you should know as well. The attorney for the Browns was the Supreme Court Justice Thurgood Marshall. He wasn't a Supreme Court Justice at the time, but he subsequently was nominated to the Supreme Court by President Johnson. He served for 22, 23 years on the Supreme Court. He's a Supreme Court heavyweight. You gotta know who Thurgood Marshall is. Now, that's an interesting case. But the point of that case was separate is not equal. Separate can never be equal. And that's a great example of the sociological school. A couple of other schools that you should know of. Another important one is the law and economics school of thought, philosophy. It believes that laws should promote market efficiency and also economic well-being, that should be the central focus of the law. Another school of thought, of philosophy, is the command school. And that is that laws are developed by an elite, no matter who it is. They develop the laws, and whatever they say goes. Another school of thought is the analytical school. Law should be shaped by logic. And there's also the critical legal studies school. These last couple you don't really need to know, but I thought I'd put them out there. That conflict should be resolved basically by arbitrary decisions, trying to find a happy medium between the two opposing sides. I'm not really a big fan of that school of thought. I don't think most attorneys are. Most attorneys, I think, would take the point of view either their client is right, they're right, or they're wrong. Not to take some kind of middle ground like that. All right. So we covered the differences of the criminal versus civil, and also what's needed for a law to be valid. It has to come from a controlling authority, and also the different philosophies of law. What function does the law serve? Well, perhaps the most important function is to, at least from a business perspective, is to facilitate planning, particularly in commerce. And we have commercial laws. There are lots of commercial laws. We're going to talk about the UCC and contract law in class. Um, but basically, um, that's probably the most important function, facilitate planning. It helps businesses allocate their risk, make plans for the future, things like that. It also gives confidence, and then the point is, if you enter into a contract, in one state, you should know and feel that's enforceable in another state. Another function of the law is to keep the peace. Certainly that's a function of criminal law. Another is enforcing moral standards, enforcing moral codes. Examples of that: drinking age, drug use, gambling, prostitution, stuff like that. Another function of the law, well, we have a U.S. Constitution. In that Constitution, we have a Bill of Rights. Bill of Rights are about what? Maximizing individual freedom. So that's another important function of the law, maximizing individual freedom. The law also provides a forum for the orderly change of society. That, if you want to bring about a change, you can lobby your controlling authorities. You can win a lawsuit, or you can lobby your elected legislative representatives and bring about change to that law. So they facilitate the orderly change of society. They provide a basis for settlement. The law actually is fairly clear. I mean, I know it gets a lot of bad press, but both sides, we're going to talk about discovery and other aspects of bringing a lawsuit. But by the time a case is ready to go to trial, both sides really know the strengths and the weaknesses of each other's arguments. And that does help facilitate settlement, which is important. The fact of the matter is that with civil lawsuits, 90 to 95% settle before a jury makes a decision. So they provide a basis for settlement. Now, what about qualities of the American legal system? How would you describe the American legal system? If someone came from abroad and they asked you, well, what do you think of the American judicial system, what would you say? That's a tough question to answer, but I think that the American judicial system, the American legal system really has three characteristics. First, it's expensive. Make no mistake about it. It's expensive. Between attorney's fees, court fees, expert fees, litigation, even for modest lawsuits, can be very expensive. So it's expensive. Second, the American legal system is actually pretty flexible. It's flexible in terms of adapting to changing societal norms. An example of that, perhaps, is same-sex marriage. We see a number of states have legalized same-sex marriage. Technology. We have the internet now, and actually laws protecting the internet go back 10, 15 years before the internet ever became popular. So it is flexible. It is flexible. And the law is also fair. But it's important to note, it's not fair in terms of outcome. It's fair in terms of procedure. If you want, you will get your day in court. You will be put before a judge. You will have a jury of your peers. It's fair like that. It's not fair in terms of outcome. You may not like what the judge decides. You may not like what the jury decides, but you had a shot. It's procedurally fair. Not result fair, not result oriented. You may feel as if at the end of the day you didn't get what you deserved, but you got an opportunity to go in front of a judge. You got an opportunity to go in front of a jury. Okay. Now, what about the history of the American legal system? This is important. Where does it come from? Well, obviously, uh, the country was originally 13 colonies, and these colonies were British colonies, stretching from Georgia in the south all the way up to Maine in the north. So we had 13 colonies, and they were British colonies. And the early settlers basically adopted British law. They adopted the English common law system. Now, the English common law, not too many countries follow the English common law system. Obviously, Britain does, Australia does, India to some extent does, the United States does, Canada to some extent does. But the English common law system is based on the idea that judges make law. They make law by writing their opinion. And they make law by following their earlier decisions. So in other words, if you have two parties, A and B, they have a dispute, perhaps a land dispute. They would go to the local magistrate, present their case to the local magistrate. The local magistrate, the judge, would make a decision, A versus B. If it was a good judge, it would write their decision down, right, and keep it in storage. A month or two later, C and D have that same, almost the same exact land dispute. They go to that same judge. What does the judge do? Well, the judge says, you know what? I've decided a case strikingly similar to this before. What did I do in that case? So the judge will look to his or her earlier decision to make a decision in the case of C versus D. So the judge would look to the case of A versus B and apply it to C versus D. Precedent. That's referred to as precedent. Another term for that, very important, stare decisis, S-T-A-R-E, decisis, D-E-C-I-S-I-S, stare decisis, precedent. Another important part of the English common law system is the hierarchical nature of it. What I mean by that is there are lower courts and there are higher courts. Lower courts handle most of the work. But suppose you didn't like a decision of the lower court. You can appeal it to a higher court. And if that higher court decides the lower court was wrong, they will overrule. They will overturn the decision of the lower court. So the English common law system is based on precedent and also a hierarchical nature, that higher courts have more authority than lower courts. Now, there's only one state in the United States that does not follow the English common law system, and that is Louisiana. Why? Well, because Louisiana was what kind of colony? It was a French colony. And at the time that we purchased Louisiana, it was governed, well, France was governed by who? Napoleon Bonaparte. Napoleon Bonaparte instituted a civil law system. Now, a civil law system is very different from the English common law system. In the civil law system, laws all come from the legislatures. Judges' opinions are not laws. Judges' opinions don't matter. The only thing that matters is what the statute says, what the law says as it was passed by the Louisiana State Legislature. That's the only source of law. Now, what has happened over time in the English common law system, in states that follow the English common law, like New York, going through judges' decisions became very time-consuming and expensive. So the legislatures in these states, in New York State, for instance, basically took the common law and adopted it into statutory law. Okay. So that's the history of the American legal system. And where do laws come from specifically in the United States? We talked about judicial or legal philosophies, but specifically, well, the most important source of law is the U.S. Constitution. It establishes the federal government and enumerates its powers. Powers not specifically delegated to the federal government are left to the states. States also have constitutions. There are state constitutions. They establish a state government and enumerate their powers. Another source of law are statutes and ordinances. Statutes are passed by state legislatures and the Congress. Ordinances are passed by local legislative bodies like City Council, New York City Council. They pass ordinances. If you have a board of trustees in the village, they pass ordinances. So statutes and ordinances are also another important source of law in the United States. Treaties are also another important law. Now, only the federal government can enter into treaties with other nations. You know what? States can't. New York State cannot enter into its own trade agreement with South Korea. That was done by the federal government, representatives from the federal government. So treaties, they're usually negotiated by the president, and they're passed by the Senate. Executive orders, very controversial source of law. Basically, these are orders that are just written into effect by either the president or governors of the state, and they do not have a legislative approval. So when we talk about constitutional law, that has a lot of people concerned. Doesn't make a difference what your political persuasion is. Presidents from both parties have been increasingly using executive orders to get their agenda done. And this has a lot of people concerned because who should be making laws? It should be the legislatures that are making laws, not the executive branch. The executive branch, as we'll learn, is supposed to be about enforcing the law, not making it. So this has got a lot of people concerned that increasingly presidents are using executive orders. Administrative agency regulations and orders. It's often said that the devil is in the details. So what are administrative agency regulations and orders? Well, the IRS tax code is a great example of that. Congress passes the tax law. That law is put into effect by the IRS, the Internal Revenue Service, when they draft the tax code. The tax code enforces the tax law. Now, as long as the tax code and the tax law are consistent, there's not a problem. But every once in a while, there's an inconsistency. The tax code goes beyond what was imagined in the law, and that becomes an issue. But still, administrative agency regulations and orders are an important part of an important source of law in the United States. And as we mentioned before, judicial decisions are also an important source of law in the United States. When the Supreme Court writes an opinion, that opinion becomes law. All the courts underneath it, all the state courts have to follow it. They have to follow it. Now we have, we could potentially have a conflict though, because I mentioned a couple of different sources. I mentioned, for instance, the U.S. Constitution, which is the Constitution for the federal government. But the states also have their own constitutions. What if there's a conflict between the two? Which one takes priority? Well, in the U.S. Constitution, it states quite clearly that the U.S. Constitution and its statutes passed and its treaties, they are the supreme law of the land. If there's a conflict with a state or local law, the federal law controls, the federal Constitution controls. Federal statutes, laws passed by Congress, they take precedent over federal regulations, administrative orders. And the federal law also takes precedent over conflicting state or local laws. All right. So that concludes our first lecture in this series. Please, again, if you have any questions, please email me your questions. I'm also around the campus if you are. I mean, I'll be on campus Tuesdays and Thursdays this semester. I'm basically free 9:30 to 11:15 or something like that. 11:30, 11:40, I think. So you can just come by and see me. I'm usually in the 5th floor, the townhouse, if you have any questions. Otherwise, please email me. Thank you, and look forward. I expect you to go on to the discussion board. I will post a discussion question. Participation is a big part of the grading scheme, so I do expect you to participate. Thank you, and have a good day.